Welcome to the 7th edition of Legal Affairs. I'm Stephen Yap. Today we will talk about the protection of personal data under the Personal Data Privacy Ordinance and its 2021 amendment. In the studio today we have Mr. Stephen Wong, former Privacy Commissioner for Personal Data and Senior Consultant of the Hong Kong Legal Exchange Foundation. Good afternoon.
Good afternoon, Stephen.
Yes, Mr. Wong, please could you give us a brief introduction to the scope of the Privacy Ordinance and its 2021 amendment?
Yes, let me first thank you for having me today. This is a very interesting topic from my point of view because we're talking about the legislative framework in Hong Kong about personal data protection. This framework is indeed one of the first legislative frameworks or legislation in Asia. It has been enacted since 1995 and put in force for about 25 years. And most important of all these rights, known as fundamental human rights in relation to privacy, as in many other human rights, the protection of these rights is guaranteed under the basic law. Nevertheless, like many other rights, human rights, like press freedom or freedom of expression, privacy right is not an absolute right. It is a qualified right. What it seeks to protect under the Ordinance 1995 is to ensure that the personal data, which, as we say, should be under the control of the person from which the data is obtained, is adequately protected. How do we protect the personal data or privacy? The law, the ordinance sets out 6 major data protection principles. There are quite a number of exemptions. Exemptions only avail the person who breached the principles, certain principles, not all of them, individual data protection principles only. If they fail to comply with the requirements of individual data protection principles, they may consider taking the matter forward by producing evidence, saying that they could be exempted under the ordinance. Now these exemptions, broadly speaking, amount to issues of public interests. I think that is fair, right? If you have public interests to care about or to look after, to protect individuals' privacy rights, and they must give way. So crime prevention and prosecution is one of the exemptions. Security and defense of Hong Kong, of our country. Bear in mind that we recently had the enactment and enforcement of the national security law. So this is one of the exemptions that may apply when personal data privacy right has to be breached. Another exemption relates to conducting statistics and research for academic purposes, for research purposes. News activity is another one. Protecting a data subject's health is a very topical one. Last year, the Personal Data Privacy Amendment Ordinance 2021, effective from the 8th of October last year. This is in relation to what happened over the last 2 to 3 years. Data was used as a weapon, the weaponization of personal data. You may recall that during the last 2 years, or even now, despite the number is dropping, personal data of certain people, including law enforcement officers and their families, were reviewed mostly online, okay, so that the subject concerned, the police officers included, may be subject to certain intimidation, certain harm, including bodily harm, threats, harassment, and as a result of which they suffer from these intimidation, threats, and harms, and they suffer mental or psychological health harm, damage to their own work process, and so on. So this is something that we need to address. This piece of amendment legislation criminalized the act of providing or disclosing personal data of other persons without these people's, the concerned parties' consent, with a result of causing harm or intending to cause harm, bodily harm included, to the parties concerned or their family members. So it made doxing, weaponization of personal data, a criminal offense.
In recent years, there has been public concerns over inadvertent misuse of personal data by financial institutions and governmental bodies. Now, have appropriate sanctions been taken, and what sort of remedies have been made available?
The ordinance itself lays down the regulation and principles and also the sanctions. It's a matter of enforcement. Of course, regulators all over the world have some sort of problems in relation to enforcement. And that's why they coordinate their efforts and form a coalition or enforcement network. I think the main reason is because personal data has no border. It's what we call sans frontier data. They have no borders, no frontiers. Just imagine data can be transferred through internet instantly. So sanctions, yes, there are sanctions, but it's not as effective as expected. Particularly in relation to the use and transfer or sharing of personal data. Okay, now, as I said before, this purpose must be the same as the purpose for which the data was originally collected. So when the banks, for example, financial institutions, collect data from a person, this must be made known and clear to the individuals concerned. If this purpose of transfer was not made known and clear to the individuals concerned, then it is a breach of the law. Okay. Very often, consent, the issue of consent is often argued in court or outside court, because what sort of consent would amount to a legal consent? Consent in the legal sense. For example, the consent must be voluntary, must be explicit, must be express, or can silence amount to consent? Now we have the doxing, okay, the disclosure of personal data without the consent of the data subject, with a view to causing specific harm to the person concerned and their families. So these are the criminal offenses. We have quite a number of criminal offenses set out in the ordinance and the amendment ordinance. Now for these offenses, criminal offenses, the sanction would be a criminal one. In other words, they will be prosecuted. Now that the Privacy Commissioner has the power to investigate and also to initiate criminal prosecution, so the sanctions is wider. The sanction that may be enforced will be more comprehensive and hopefully more effective.
Now, does the Office of the Privacy Commissioner for Personal Data, being a law enforcement body, initiate prosecutions for contravention of laws and regulations under the Privacy Ordinance, or is it left to the Department of Justice to do so?
We can answer these questions in two ways. First, in relation to the original Privacy Protection Ordinance, enacted in 1995 until the amendment ordinance of last year, 2021. The first part, the answer is very simple. There was no criminal investigation power on the part of the Privacy Commissioner. Okay, and therefore, the police or other law enforcement officers will have to be relied on for investigation purposes. There was no prosecution powers either on the part of the Privacy Commissioner. So for prosecution's purposes, the Department of Justice will be the only organization or authority to bring the case to court. But since the Amendment Ordinance 2021 in relation to criminal doxing was enacted, the Privacy Commissioner was given additional, new powers to address criminal doxings by one, having the adequate power to investigate, two, having the power to bring charges or prosecutions to court. So these investigation power include the power to stop, the power to seize, to search, and to arrest a person. And the Commissioner may also apply for a warrant to enter and search the premises, or to access, search, and decrypt information stored in electronic devices such as a mobile phone. The Privacy Commissioner can also issue what is known as cessation notice. In other words, asking the offender, including the service provider, the network service provider, for example, to stop revealing or disclosing offending messages, doxing messages. So they have the power to issue a cessation notice. They can also apply to the court for an injunction order to stop the disclosure or the revelation of the messages on, for example, an online platform. So they have the requisite power to investigate. They have the requisite power to go to court, to ask for assistance from the court by issuing injunction orders. They can issue cessation notice to the party concerned, including the network provider, whether in Hong Kong or overseas. Even if they are operating outside Hong Kong, the Privacy Commissioner can issue the cessation notice to the party, outside Hong Kong. And at the end of the day, if there is sufficient evidence, the Privacy Commissioner, can prosecute, the cases and also the offenders in his or her own name, so that they could have what we call a through train, power services from the commission of the offense, to the decision of the court on the offense or the persons charged.
Thank you, Mr. Wong. That is the program for today, and thank you for watching Legal Affairs. See you next time.
Bye.